As my co-counsel said at the beginning of this morning, I'll say again, and as we've said throughout this process, we appreciate your attention. Today has been a heavy day. And the two words that I think of that describe it is insurmountable loss. We're not here to take away from that or to in any way suggest that that's not what has happened. And the district attorney, made a statement. He said, how could there have been anyone, something to the effect of, that wouldn't have been moved by what they heard this morning? And I would agree with that. I was moved. How could you not be moved? It's tragic. But when you go back into that jury room for this portion to deliberate about this, the judge is going to instruct you that your emotional response to the testimony this morning cannot be the basis for the sentence that you render. It can't. The law doesn't allow it. And the district attorney talked to you about the sentence that the law requires, that justice requires. And it's interesting when you think about that concept, because in reality, although he didn't say it, and I understand why, law and justice requires you to consider the mitigating circumstances. It requires you to consider Mr. Reinking. It requires it. Justice demands it. The law demands it. And that's not to say or to take away from anything that these victims, and they are, undoubtedly have suffered in this case. And you should not feel bad if you are considering Mr. Reinking, because the judge is going to tell you you have to. The legislature says you have to. And it's hard. There's no doubt it's hard. To see that, to hear that, to know that, and still have to take that step. But it's what law and justice demand. And there was a conversation that the district attorney was having with you about minimum punishments and what punishments. And it's interesting when we took that in with the law. And let me make one thing straight right now. As much as your hearts go out to the victims, know this: nothing you do today is going to make them whole. It won't ever make them whole. And that's one of the reasons it's not your job to make them whole. You can't. And that's one of the reasons why the law says emotion can't be the driving force. It can't be the consideration. Because if that were the consideration, who wouldn't do it? Right? But it can't be. You have to take that out and look. And you have to ask yourself a question. When you're determining a sentence in a case like this, and remember, the district attorney's office, they decide what punishment they want to seek. And it's up to you to decide which one is appropriate. Now, he started off talking something about the death penalty, right? They didn't seek it, right? So he's trying to cause you to do this driving, this kind of thing where you're looking at all the three punishments and this is the minimum. If they thought that was appropriate, they could have asked for it, and you would have been considering that, but they didn't. And by not, you can tell yourself, they didn't think that was the appropriate punishment. These are the two. These are the two. We understand by your verdict that you disagreed, that Mr. Reinking could not appreciate what he did was wrong. But the legislature saw fit as a mitigating factor for these exact circumstances where a jury has heard substantial proof about someone's severe mental illness. And by the way, the state never disputed that Travis Reinking suffered from a severe mental illness. For this very incident. And you're going to read in the jury charge about how there's a specific jury instruction that talks about what mitigating circumstances we saw. And one of those is that the capacity of the defendant to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law was substantially impaired as a result of a mental disease or defect. And then it goes on to say, which was insufficient to establish a defense to the crime, but which substantially affected his judgment. Based on what you heard in the trial from the experts, is it even a question that Mr. Reinking's judgment was substantially affected? Is it even a question? And you've chosen not to say that it warrants him a not guilty by reason of insanity, but can you really say that it doesn't apply here? When you look at that YouTube video, you remember the YouTube video of Mr. Reinking talking into it? When you heard the testimony from both of the experts, whether it was being brought out by the defense or from the prosecution, that Mr. Reinking suffered from significant delusions, what his perception was that night. What did he perceive? And the one consistent thing that we've heard from the state is their attempt to try to apply reason and logic to someone who was out of their minds. It doesn't fit. And way back in the opening statements, when we first started this journey together, I talked to you about perception. And it's appropriate for you to consider that proof and Mr. Reinking's perception of what was going on that night when you're determining the sentence. It's not a small thing. A life with the possibility of parole sentence is not insignificant. It will be 51 calendar years before he would even be considered for parole. He's 33 years old today. He's 33 years old. The minimum, as they call it, is substantial. It's substantial. Another mitigating circumstance is that the murder was committed while the defendant was under the influence of extreme mental or emotional disturbance. Who of you, after hearing this proof, can say that that wasn't there? Travis Reinking is sick, was sick, and had been sick for a significant period of time. Now, the district attorney talked to you and he said, it's not a mathematical equation. He's right about that. When you're weighing what to do on this sentence, the aggravators and the mitigators, there's no magic number. And as Mr. Bruno told you during his opening statement to the sentencing hearing, the last mitigator that we list is that basically anything you found to be mitigating, you can rely upon that. You know, the other thing is there's a mitigator that's listed, and it says the murder was committed under circumstances which the defendant reasonably believed to provide a moral justification. Remember what the testimony was. In his untethered mind, that was completely devoid of anything from reality, he thought he was morally justified in his actions. Now, in reality, was he? No. We're not here trying to tell you that, but that's, again, where we talk about trying to apply logic and reason to crazy. When you go back into the jury room and start deliberating on this, you have to look inside yourself and make a determination, each one of you. And on behalf of Mr. Reinking and Mr. Reinking's family, who is in this courtroom, his mother, his brother, his father, his aunt and uncle, in support of him, no one's asking you to forgive him. No one's asking you to excuse him. But what we are asking you to do is look at these mitigating circumstances and question, if this wasn't a reason to give a lesser sentence in this circumstance, why would the legislature why would they have done it? Why would this be here? Why would they put these mitigating circumstances in here for you to weigh against? They wouldn't have. And we're asking you to come back with a verdict, or excuse me, with a sentence in this case of life with the possibility of parole. Thank you so much for all of your attention.